This video is made possible by Second Call Defense. Second Call Defense provides immediate, upfront legal protection for a member who is forced to use any legal weapon for self-defense. So protect yourself today with Second Call Defense. I did. You'll find the link in the description. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm super grateful for everything you do, so I hope that you won't stop. Please do consider checking out GunGuyTV Crew. That's a great place for you to support GunGuyTV and get access to exclusive content you can't get anywhere else. You might also check out the GunGuyTV Firearms podcast. It's an audio podcast that appears every month on your favorite podcast player. And if you get a chance, check us out on these additional locations as well, because sometimes YouTube can be a little sketchy and these other places are very, very reliable. Places like BitChute, Rumble, Odyssey, and so on. The videos will always be there. All right, we're going to talk to Sean Maloney from Second Call Defense. Now that the dust is settled on the Kyle Rittenhouse case, it might be nice to look back at it and decide what lessons we can learn as gun owners, people who carry firearms every day, or people who have firearms for home defense from that particular case. So I thought I'd get Sean to come over and talk with us about it, since he's spent decades as a defense attorney in self-defense cases. So without further ado, let's go talk to Sean. Sean, thank you very much for joining me. I appreciate you coming back on the show again. You are the expert in Second Amendment, or I guess I would say self-defense law, and I certainly am not. And good night. We got a lot to talk about. We got the Kyle Rittenhouse thing, which I think is key to talk about for folks, because there's a lot we can learn from that, I think. And then we've got the shooting that happened at the school, which I'm not as versed about. We've got the viral video of the gentleman who went to go pick up his child, got in an argument with the biological mom, I guess, and got shot by the boyfriend or somebody that had a little pistol caliber carbine. That was kind of shocking. But if you don't mind, let's talk about can we talk about the Kyle Rittenhouse thing first?
Sure, I'd love to.
Okay. So here's some things. I mean, if let me go back a little bit. So if you're watching this and you're old enough to remember, you remember the Rodney King riots. I remember those because I'm an old guy. And we have the kind of iconic pictures you saw on TV, you saw of the Korean shop owners defending their stores and that kind of stuff. And then the horrible images of Reginald Denny being dragged out of his truck, hit with a brick or a block or something, and left crippled for the rest of his life. And so people tend to hearken back to that and say, well, if there's a riot in my area, I'm going to get my rifle, get my gun, whatever, and I'm going to do what the Korean shop owners did. But the rules seem to have changed quite a bit. Now we have, I wrote my notes here so I didn't forget it. I was kind of astounded when I read it myself. We have the governors and legislatures of certain states, like California, for instance, releasing violent criminals on the streets constantly. We have states releasing criminals without bail because they want, quote unquote, bail reform. If we're nice to criminals, they'll stop being criminals. That's not working out. We have prosecutors refusing to prosecute criminals. And then if you start looking at that altogether, there's no real penalty for these folks when they riot or loot or attack people or whatever. We saw that in 2020, in the summer of 2020, with the BLM and Antifa riots all over the place. And then we've got defund the police, vilify the police, ordering police to stand down. Some mayors and governors have done that, refusing to call in the National Guard when they were needed. Kenosha is an example of that. Calling riots mostly peaceful protests while the town is burning behind the commentator on national television, and injecting race into everything, even when race is not involved. Kyle Rittenhouse did not shoot anybody except white guys, and Carl's a white guy, or Kyle rather. Kyle, he's a white guy. And then attacking the defenders as if they're the criminals. I was struck by Kyle Rittenhouse's the prosecution breaking the rules, disobeying the judge, doing unconstitutional things in the courtroom. I don't know whether that's normal or what. And then even going back to the McCluskeys or however in St. Louis, Mark and Patricia McCluskey, they were just standing on their front yard with their guns. So now that I've kind of painted the picture here and bored everyone to death, there's some things that came to mind. I mean, what message does this send to gun owners who might be put in a position where they have to defend themselves? Are we just sunk at this point, or do we still actually have an ability to defend ourselves in this country?
Well, Joel, in my view, I think the Rittenhouse case was more about what you were just talking about, removing our ability to protect ourselves in the case of riots and mass demonstrations like that turned violent. I think certainly Kyle's ability to use a lethal force self-defense when necessary, as it was on trial also. But more so, I think us as a society, law-abiding gun owners, they were hoping to send us a message. You can't come out in the streets and you can't protect yourself, you can't protect your property, and you can't protect your loved ones. And I think that the left or the anti-gun media, that's what they came out swinging. And that's what they were essentially attempting to do. Because you, as well as I know, based on the evidence of that case, there is no way that ever should have went to trial. Self-defense, purely and simply, it's a testament is when to properly use a firearm in self-defense. You're in immediate fear of death and serious bodily injury or harm. You didn't instigate the matter, and you had to do something right now. And Kyle acted properly. And unfortunately, and part of the reason why I started second call defense was because I had many clients that were persecuted. Election year, you have a very liberal or anti-gun prosecutor. You can't control that. You just have to hopeful that you get a fair and biased jury. And fortunately, Kyle did in this situation. And what a jury he had. The guts that these people had, knowing not being recused, marchers on the streets. They knew what was going on, and they knew potentially what their verdict could do. But they stood up and they were strong enough to do the right thing.
Well, they took their time and really deliberated like a jury should too. But you mentioned the word persecuted. I watched a lot of that trial, as much as my schedule would allow. And it really did come across as a persecution, not a prosecution. And so in light of that, if this is the kind of stuff that happens, I thought about this young boy. I mean, he's a kid to me. I'm an old man. My children are all older than he is. What can we expect if any of us are forced to be in a situation where we have to defend ourselves with a firearm, or any weapon for that matter? Do we expect the same kind of persecution rather than a prosecution?
Unfortunately, it depends upon where the shooting takes place. Even in the state of Ohio, where I'm from, if in Cincinnati, Ohio, I know my prosecutors and I'm pretty safe. But it's not really a pro-gun area, but certainly not an anti-gun area. But you go to Columbus, Ohio, and Cleveland, Ohio, and the narrative changes completely. It's very, very progressive, very anti-gun, and the prosecutors treat self-defense cases much different up there. So we can expect, hopefully, to be treated fairly, but be ready for the fight of your life. I tell people that oftentimes the fight for your life is followed up by the fight for your life. When you're in front of a juror, or you get a prosecutor, be it a quote unquote bad prosecutor or whatever it is, you have to be ready. And unfortunately, I wish I could say if you use your gun properly, if the person had the ability to harm you, had the opportunity to harm you and put you in fear for your life, then you can properly act in self-defense. Hopefully that's enough. But unfortunately, as we've seen in George Zimmerman years ago, and much the same way in Kyle Rittenhouse, you can't rely on that. Political motivation from a human being, a prosecutor, can go a long way in ruining somebody's life and spending an awful lot of money. So you have to stand ready and be prepared. And when I speak to people, I always try to let them know that, please, your life is still more important than what you're going to go through in the end.
I'm sorry, I didn't mean to interrupt you. Go ahead.
Well, that's all right.
It's interesting what you say about defending your life after defending your life, because even if you look at Kyle Rittenhouse from this point forward, he's still defending his life. I mean, he's trying to go to school in Arizona and they're trying to boot him off of the campus. He's going to face that kind of nonsense for a long time, pretty much everywhere he goes. So they vilified him in such a horrible way by making this such a public spectacle, which it didn't necessarily need to be. I mean, I'm comforted by the fact that most I would assume, you have to tell me, that most defensive shootings end up going through court without being a public spectacle. Isn't that the case?
Yeah, that's the case by far and away. And I found even throughout the country that times have changed so much, with now some 20 million concealed carry permit holders estimated on the streets, with all the 21 or 22 states now that have constitutional carry, that things have changed quite a bit. But you can still end up at the wrong place at the wrong time, so to speak, and still have to defend yourself. But, I'm hopeful that as things move forward, the laws get better. And I'm truthfully, I'm hopeful that the prosecutor in the Rittenhouse case is sanctioned. I don't know if it rises to the level of disbarment, but certainly what he did, where, questioning somebody's silence is like the number one no-no. And so I feel confident also that no matter what the jury did, that probably would have been dismissed with prejudice, because he directly went against what the judge said, and then directly stepped on the holy ground that as a prosecutor, you never mention a person's right to silence, right to remain silent, and not to testify. And Kyle did. So there's a lot of things going against Kyle, including the media. But truth won out and the facts won out.
Well, and I, as a longtime firearms instructor, and not an amateur, not somebody who just did it on the side. I mean, I've been a professional firearms instructor for a long time. I look at what that kid did with the firearm, and it was textbook perfect in a lot of respects. I mean, he did not shoot at people who were not threats. He only shot at people who were threats. He was very, for a guy who was 17 at the time, I was very proud of the way that he handled himself during a very dangerous and life-threatening situation. So, and then watching him testify in court, I was like, he's got a lot of maturity, which is quite clear. It's interesting though, because it was publicized the way it was. I mean, the kid was kept in jail for 87 days, and they had to go out and get donations for bail. His bail was $2 million. Of course, I don't know about Wisconsin, but in a lot of states, you can get a bondsman to post that for a small percentage, like 10% or something. I don't know what the normal bail amount is for a defensive shooting. Is that normal, or is that a huge amount beyond what it would normally be if it wasn't publicized and politicized?
Well, in my view, I thought it was a huge amount. It was wholly unreasonable. I mean, Kyle certainly wasn't a flight risk. He wasn't a danger to society. He was going to, rest assured, everybody knew who he was, and he was going to turn up and show up for his hearings, and certainly for a trial. So I thought bail was entirely excessive. And it was a shame that he spent 87 days in jail, because certainly that's no fun at all. And as an attorney, the last place you want to go to prepare your client for the fight of his life is in a jail cell. And try to prepare him for direct and cross-examination, behind prison walls. And for all that time, emotionally has a huge impact on especially somebody that's 17 years old. And trust me, he's not the same person after spending that time in jail that you and I are.
No, he can't be. In fact, he mentioned during the tail end of his trial that when he asked if he'd had any mental issues in the past or anything, he hesitated. And the attorney said, well, the reason he hesitated is he's in counseling right now because he's got PTSD because of the incident. So he's going to be dealing with that in counseling for a really, really long time. Going forward, though, I carry a gun every day. You probably do. Most people I know do every day. And so hopefully if we're law-abiding folks and we go out of the way to try to avoid trouble, we'll never need them. But in the instance that we do, if he had not had people donating money, and who knows where the money came from to pay for his defense, but that's an incredible thing. I mean, there's no way I own rental properties. I have a business that's successful. I have a ranch and property in the White Mountains of Arizona. I can't come up with $2 million for bail. And I'd have to sell a property to come up with $200,000 if it was a 10% deal.
Right.
And so if I'm an 18-year-old kid, I can't do any of that stuff. And I have a feeling that nobody's going to be donating to my defense probably. So how do, I'm kind of setting you up here, I guess, a little bit, but how does second call defense approach that to make sure that the average gun owner doesn't find themselves in that financial pickle?
Obviously, with a bond amount that much, and the anomaly of Kyle's case, that's a huge amount of money. Second code offense sets money aside to pay up to $250,000 or more, because we can go back to the foundation for bond. And I always tell people, there's probably 7 or 8 states that don't recognize bond companies, and Wisconsin's one of them. And not to get into it real deep, the majority of states, including California, for example, if we go to a bail bondsman and we put up $20,000 for 10% of our bond, we never get that money back.
That's right.
And I always remind people of that. You're not getting that money back. So second code offense was set up to provide bail money for our members, so that bond money is there. And we've used it probably dozens of occasions. We had a case in Illinois, a person from Illinois, and a case in Indiana. Illinois doesn't allow bail bondsmen to go after people who skip bail. So I had a hard time finding a bondsman in Indiana to bond out an Illinois resident, because essentially they couldn't let them go. So I went to our foundation and I got an extra $20,000 to put down as collateral that would have went away if certainly our client wouldn't have returned. But second code offense is specifically set up so we can bail somebody out, and we're set up to do that, bondsmen throughout the country. And actually came from a real live case I had. I'm also an NRA instructor, and I taught a group of individuals concealed carry. And some 3 weeks later, one of the 21-year-olds that I taught was a victim of road rage and was forced to brandish his firearm. Of course, the true bad guy made the first call to the Fairfield police, and my client drove there because he lived there. And as he pulled into the parking lot, the entire police department was emptying to go after the guy in a black Ford F-150 4x4 four-door that just pulled up in a parking lot, and they tackled him. And I decided there had to be a better way, because his 21-year-old wife with 2 small children and I went door to door for about 4 hours. On a Friday night, the relatives, the friends, breaking into piggy banks, going to ATM machines, doing everything I could do to get $10,000 for his bond. He was charged with originally felonious assault, which was an overcharge, purely because I knew that this young individual would not be the same on Monday morning after he spent a weekend in the Butler County Jail. And so that was part of the thing I specifically set up, because I can prepare you better if you're not in jail. And that's an experience that nobody should endure.
No, not come out the same as you went in. That's for sure. We're looking at the outlandish costs of the Rittenhouse trial, which are, $2 million bail, you said is exorbitant. You didn't use that term, but basically that's the word. And so the cost of the attorneys have got to be quite high. They're hiring investigators and expert witnesses and all kinds of things to mount an effective defense for their client. What is the average cost of bail in these kinds of things? And what is the average cost of court and lawyers and whatever for that criminal part of defending yourself if it actually ends up going to trial? Well,
generally speaking, in a self-defense shooting, there's really no crime involved on a pure self-defense shooting. And as a prima facie case on its face, you can generally tell that someone acted in self-defense. So normally bond amounts aren't that great. And usually the only time that they're over a few $100,000 if the person isn't from that area and may go home and not come back. But generally speaking, bond amounts are somewhere around $10,000 or $20,000. You're 10% of it. Around $100,000 or $200,000 has been my experience. And then generally speaking, somewhere under $100,000 if it's a full-blown criminal defense and criminal trial with investigators, forensic science, and everything in a week-long trial going forward. Generally speaking, that's what it is. Of course, I say that the Rittenhouse case and Zimmerman were anomalies. And in Kyle's case, I think that from the best I can tell online, somewhere between $400,000 and $500,000 is his final tab. Now, it's important to know that as an attorney, if I'm representing you and we're in trial and the meter's running and the bell goes off and you're out of money, I just can't say, Judge, I'm done. I'm walking away. as an attorney, I can't do that. It's my responsibility to zealously represent my clients within the bounds of the law. And because they run out of money, isn't a reason to jump ship, and the court won't let that happen. But after it's over with, and after you're acquitted, or if you're convicted, you still owe that money, and that money is still out there. And so that's one thing that we tried to do from the criminal defense standpoint, is provide enough money for the 99.9% of the cases out there that'll put on a defense and that'll properly represent our members of second call defense. And so far it's been working flawlessly. But like I said, thank God people took an interest, and I happened to be looking online today at all the different people that had donated money to his defense. And it was a wide range from actually Hollywood actors to the My Pillow guy. So everybody.
Mike Lindell strikes again. Yeah. I may go online and buy a pillow today just to support that dude. I love it.
I was actually Christmas shopping online for his pillows for that just reason. So I was impressed.
Yeah, I love Mike Lindell. He's great. He's just a real guy. I love him. Well, what's interesting about that is if I was a bail bondsman for a while. And so the problem is that in a state where you actually have a bail amount where they're not just going to cut you loose, or they're not going to cut you loose on your own recognizance. I started to say, or then if you can't post bail, you just sit in jail until your case is done, basically.
Right.
What happens if you don't have the money to pay an attorney? I mean, how does I don't really know a lot about how the defense actually works in that instance. So let's say I don't have any money at all. I can't post bail. I'm going to sit in jail, which means I can't raise money because I'm sitting in jail. I can't go to work. I can't run my business. I can't do whatever because I'm sitting in a clink. And now it comes time for me for my preliminary hearing and for my court case and whatever. How does that work when I don't have any money?
If you're indigent, you don't have the money for the attorney, you're going to get the luck of the draw, and generally a draw, and you're going to get a public defender. Now, public defenders are great attorneys. They probably have equal ability as most attorneys out there, but they lack one thing, and that's funds. They're going to get paid basically a small hourly amount, or their hourly amount, which in no way is going to be what the best attorneys in the country are going to charge. And at the same time, their limited resources aren't going to allow you to have a lot of forensic scientists, or a lot of tests ran, or a lot of private investigators chasing down a number of witnesses or anybody that can help you out. So really, you're behind the curveball at that point in time. Not that public defenders don't have the ability, they do, but they just have the limited resources, and you're not going to get the best defense possible because they simply can't afford the private investigators because the state's paying for you. And the money's not out there for that.
So, I mean, basically, correct me if I'm wrong in this estimation. Had Kyle Rittenhouse had to defend himself using a public defender, he would have been found guilty and probably be sitting in prison right now.
There's a much better chance that would have happened. Although the evidence was so not in favor of not proving self-defense beyond a reasonable doubt. That was kind of ridiculous. But yeah, basically so, because if you look at all the money that I'm sure they spent on witnesses, on videos from everywhere, certainly that changes everything. So I think you're probably right in that assumption, although weak evidence in his case. But, without the right attorney, the state's probably going to prevail, because after all, the state and does the prosecutor actually arrest and prosecute an innocent person? Why would they do that?
And they do. Right. Okay. Now look, just from a personal experience perspective, as I said, I was a bail bondsman. Mm-hmm. So from time to time, when somebody FTAs, they fail to appear, then the bondsman's got to go get them, and then you got to take them to court, or you got to get yourself off the bond. Otherwise, you're responsible for the bond. You got to get the judge to take you off the bond, or whatever you're going to do. In California, you got 180 days to get them off, plus I think 5 days for us. You get basically 185 days to get them back into court again. So occasionally you get some information, and you find out that this person is going to attend a hearing for a friend, because people who do bad things often know people who do bad things. And so then you spend all day sitting in court during a preliminary hearing that goes on all morning. and you're waiting to see if this joker is going to show up, because you're going to, at that moment, you've already told the court, you've already told the judge that you're expecting this person to show up, and the judge will tell you, well, if they do, then it's my bailiffs who will do the hooking up, not you. And you say, absolutely no problem, Your Honor. And so sitting in the back, you watch this go on all day. Now, I've been through that a number of times in San Diego courts, Orange County courts, Los Angeles courts, and so on. And what I've discovered is, as you're sitting there, that you watch the public defenders and the prosecutors each sitting at tables, because they have a zillion of these cases, and they have stacks of paper that are up like this, big stacks of paper in front of them, almost looks like Donald Trump's tax return, okay, repeatedly. And so one right after another, these people come in and they plea bargain, they plead it out, and they make a deal. And so they're making deals all day long, and these people are brought in, brought out, brought in, brought out, brought in, brought out. It's a machine. It's a machine. And very, very seldom, in my experience, do any of those actually go beyond that. A plea issued at that moment, judge renders sentence, done. And I would say, not to disparage public defenders, but I think not only do they not have the money, they don't have the time. Right. Because there are so many people that need their attention that they end up with a caseload that's enormous, and they don't have time to work on those cases individually. They just try to plead them out as fast as they can. So if you're stuck and you have no money, and you can't, you're going to lose your house or whatever, but if you don't have much money, you can't work because you can't get out of jail or whatever, and you're stuck with a public defender, your chances, in my personal experience, of being exonerated are not terribly high. Unless you're in a place where you have a district attorney, Commonwealth attorney, whatever you want to call them, depending on the part of the country you're in, who is pro Second Amendment or pro self-defense, who looks at it and goes, no, there's no there, we're not going to prosecute this. That's been my experience anyway, as I've looked at it. But then when you're done, even if you get lucky, and that's the case, now, I mean, the family of the person that you shot, or the person you shot if they survived, are surely going to drag you into civil court and sue you, aren't they?
Yes, and that's one of the biggest dangers also of a public defender, and you're right. I used to do court-appointed work early on, and oftentimes the first time I met my client was in the hallway just before he walked in for an arraignment. And then I had a pretrial where I got rid of the case because the time and the money wasn't there. And so instead of Kyle getting a trial before his peers with all the information brought out, and if the prosecutor is not going to say there's no there, then it has to go forward. And the 9 times out of 10, the public defender is going to say, hey, I can get you involuntary manslaughter, or I can get 2 of those charges gone and you'll be out in 20 years. And so that's what you're faced with. And that's the harsh reality of that. And you're absolutely right. That does happen, and there's really not too many more alternatives to that but that. Unfortunately, that's one of the weaknesses in our system. Certainly the scales of justice are blind, but they're not money blind. They still see the color green.
Thank you very much for listening to all of the interview. I'm very grateful that you did. Now, so that you know, there is more to this interview than what has been displayed here. And the reason that it isn't is because I was trying to keep the time down a little bit for you. But the information is vital. So I'll be actually posting a second video to round out the rest of the interview, which is about half an hour, later in the next week or 2. In the meantime, it will also be published in the GunGuyTV audio podcast as an audio podcast episode. So if you haven't subscribed to that, I do urge you to go to your favorite podcast player and look for the GunGuyTV Firearms podcast. You'll find actually this interview is already there, and then the next part of it will be there as an audio podcast for you to consume that way before it's actually released as a video in the video platforms. All right, thank you very much for everything that you do. Have a wonderful Christmas, and wherever you go, whatever you do, stay safe.